Child custody is one of the most difficult issues, particularly if your divorce is happening in a courtroom litigation. It is not uncommon for the court to appoint an attorney for the child or also to order a forensic evaluation of the parents before making a decision with respect to custody. There are two different types of custody. Legal custody refers to the major decision-making power, not the day-to-day decisions. Those decisions would be made by whichever parent the child is with at the time. Something as simple as what should the child eat for breakfast, or if the child has a fever, whether or not to administer Tylenol. But the big major decisions is what legal custody is referring to: the health, education, religion, welfare of the child. Those are decisions that if parties have joint legal custody, that they would be making together, that they would discuss and confer before a decision was made. And that, of course, differs from residential custody, which addresses which parent the child is with for the majority of the time. The best interests of the children is to be the guiding factor for a court to consider when making a decision with respect to custody and parenting time. And that may encompass a variety of different things: where the children would be living, what school would they be attending, if the children have any sort of special needs or concerns. So a variety of factors go into that very significant determination. For parents to have joint custody in New York State, that's really referring to two different things. There is joint legal custody, whereby the parents would share decision-making power. In a typical settlement agreement, the language might say that they would discuss and confer over the major issues of health, education, religion, welfare of their child. And there would normally be some guiding language in there about what would happen if the parties did not agree. That, for instance, they may go to follow the recommendation of the appropriate professional. And then there is also consideration of residential custody. Joint residential custody would mean that the children or child is splitting time or dividing time between both parents' homes. It is possible to modify a custody order after the divorce. To do so, the parents would have to demonstrate a significant or unforeseen change in circumstances, something that differs from when they either first entered into the agreement or the order was brought down by a court. But they would have to show some change in circumstances, some reason to be making a change post-judgment to the custody and parenting time. Relocation of one of the parents would certainly be a reason to make a change to an existing custody and parenting time order. In order for a party to move to a different state or further away from their co-parent, they would really need to demonstrate that such a move would be in the best interest of the child. Courts are reluctant to allow a relocation if it would make it difficult for the child to have a meaningful relationship and consistent parenting time with both parents. If parents are experiencing difficulty and not able to come to an agreement with respect to a parenting time plan, in a litigation setting, the attorney for the child would have a lot of input into that decision. And ultimately, a court may have to make the decision for the parents. But one of the greatest aspects of the out-of-court methods of mediation and collaborative is for the parents to be able to talk about the different options of a parenting time schedule. And certainly in a collaborative setting, to be able to have a child specialist or a family specialist help them navigate those very difficult decisions to figure out what is going to be best for their children so that their children can thrive even post-divorce.